Genocide, war crimes, and crimes against humanity do not just happen.
They all begin by inciting blind hatred against a group, a tribe, a race, a religion, or a nation.
In a world of sharply increasing socioeconomic inequities, state building and state strengthening continues to depend on socio-economic development.
Cultural and religious tensions must also be adequately attended to and tactfully dealt with.
Investing in education and conflict prevention is likely to diminish the chances that such crimes will be perpetrated.
Where prevention fails and a state is manifestly failing to meet its obligations, we also need to be prepared to consider a wider range of collective measures. Only rarely and in extremis would these include the use of force.
A key question is, who will define and determine that a particular situation is a candidate for preventive or reactive intervention?
The concept of R2P is essentially about saving human lives. It should not become a license for illegitimate or arbitrary interference or aggression.
The wars in Iraq and Afghanistan are testimonial to the fact that military interventions, under whatever reason, have always entailed ever more serious human rights violations and thus further devastating the situation.
Although New Zealand supports structural reform of the Security Council, we are concerned at suggestions that such changes are a prior condition for implementing responsibility to protect. In the context of this debate, there is an issue far more important than structural reform, and that's the way in which the Council functions and the need for wide-ranging changes in its practice and working methods regardless of its size and structure.
The genocide in Rwanda was entirely preventable. The early warning signs were there. A UN peacekeeping force was present on the ground. But as the permanent representative of New Zealand reminded us yesterday, some permanent members of the Security Council debated whether to call it genocide or not while people were massacred.
The problem in April and May of 1994 was not one of powerful states eager to intervene. It was exactly the opposite.
It is clear that fears and doubts of R2P still persist. However, what is also clear is that these doubts are not insurmountable.
Further refinement of the concept of R2P here at the UN in general, and in the General Assembly in particular, will make some of the situations which skeptics have pointed to less likely to happen.
We have to make sure that there will be no room for any margin of error.
Further deliberation of experts, scholars, and practitioners of the international law on the R2P that may merit further consideration by member states is therefore more than welcome.
It is incumbent upon us to make certain that history does not repeat itself.